The world of law can sometimes feel like a different language. We encounter legal terms in contracts, news reports, and even everyday conversations. Understanding these terms empowers us to navigate legal situations with more confidence. This guide provides clear explanations of 20 essential legal terms. We'll use simple language and relatable examples. Let's demystify legal jargon together. Legal terms can seem confusing, but understanding a few essentials can make a big difference. This section introduces some of the most common terms you'll encounter, helping you feel more confident when dealing with legal matters. These foundational terms are key for making sense of legal documents, court proceedings, and everyday conversations about the law. An affidavit is a written statement made under oath used to present facts without appearing in court. An allegation is a claim made in a legal dispute that hasn't yet been proven. An appeal is a request for a higher court to review a lower court's decision. Arbitration is a way to resolve disputes outside of court with a neutral third party making a binding decision. A brief is a written document lawyers submit to court outlining the facts, laws, and arguments for their case. Knowing these terms empowers you to better navigate legal situations and communicate with confidence. Entering a courtroom can feel overwhelming with its unique language and procedures, but understanding a few key terms can make the process much clearer and less intimidating. Whether you're involved in a case or just curious about the legal system, knowing these basics is essential. The defendant is the person or group accused of wrongdoing, while the plaintiff is the one bringing the lawsuit, seeking a remedy for harm or loss. Before trial, a deposition may occur, where witnesses give sworn testimony outside of court, helping both sides gather facts. A hearing is a legal proceeding where a judge reviews arguments and evidence, often to resolve specific issues before a trial. An injunction is a court order requiring someone to do or stop doing something, often to prevent harm while a case is decided. With these terms, you can approach the courtroom with greater confidence and understanding. Contracts are the backbone of many business and personal transactions. Whether you're renting an apartment, starting a new job, or buying a car, chances are you'll encounter a contract at some point. These documents are more than just formalities. They outline the rights, responsibilities, and expectations of everyone involved. Without clear agreements, misunderstandings and disputes can easily arise, leading to costly or stressful situations. That's why it's so important to understand the language used in contracts so you can protect your interests and make informed decisions. Understanding these key terms can help you interpret and negotiate agreements effectively. When you know what to look for, you can spot potential issues before they become problems, and you'll feel more confident when discussing terms with others. Whether you're a business owner, an employee, or just someone signing a service agreement, a little knowledge goes a long way. So let's break down a few of the most important ones together. These are terms you'll see again and again, and understanding them will give you a solid foundation for navigating any agreement. First, there's breach, which is a violation of the terms of a contract or agreement. A breach can be major or minor, but either way, it means that one party hasn't lived up to their end of the bargain. This can lead to legal consequences, such as having to pay damages or even terminating the contract altogether. For example, if a tenant signs a lease agreeing to no pets but then gets a dog, they are in breach of the lease agreement. The landlord might have the right to ask the tenant to remove the pet, or in some cases, even end the lease early. Breaches can happen in all sorts of contracts, from employment agreements to service contracts, and knowing what counts as a breach can help you avoid accidental violations. Next, consideration refers to something of value exchanged between parties to a contract, and it's what makes the contract legally binding. Consideration can be money, goods, services, or even a promise to do or not do something. Without consideration, a contract usually isn't enforceable in court. Like in a contract for a new car, the consideration is the car itself and the agreed upon payment. Both sides are giving up something of value. The buyer gives money and the seller gives the car. This exchange is what makes the agreement official and enforceable. Consideration doesn't always have to be money. It could be a service, like painting a house, or even a promise not to compete with a business. The key is that both parties are exchanging something meaningful. Indemnify means to protect another party from financial loss or liability. This is a common term in insurance policies and business contracts where one party agrees to cover certain costs or damages if something goes wrong. For instance, an insurance policy might indemnify you against damage from a natural disaster. That means if your property is damaged in a storm, the insurance company will cover the costs so you're not left paying out of pocket. Then, liability is about legal responsibility for harm or damages. If you're found liable, you may have to pay for someone else's losses or injuries. Liability can arise from accidents, mistakes, or even failing to act when you should have. If you cause a car accident, you could be held liable for the other driver's medical expenses. Liability is a key concept in many contracts, especially those involving risk like construction or event planning. And finally, a clause is a specific provision or section within a contract. Clauses spell out the details, like payment terms, deadlines, or what happens if someone breaks the agreement. For example, a contract might have a confidentiality clause prohibiting the disclosure of sensitive information. There are many types of clauses, such as non-compete, termination, or dispute resolution clauses, each serving a unique purpose. By reading and understanding each clause, you can better protect yourself and ensure you know exactly what you're agreeing to. These terms are frequently used in real estate transactions, business formation, and corporate governance. Let's go through a few just to get a better feel for them. First up is deed, which is a legal document transferring ownership of real property. When you buy a house, the deed shows that you are the legal owner. Then there's lien, which is a legal claim against property as security for a debt. For example, a bank might place a lien on a house if the homeowner defaults on their mortgage payments. Incorporation is the legal process of forming a corporation. So, a group of entrepreneurs might decide to incorporate their startup to limit their personal liability. Articles of association are a foundational document outlining a company's purpose, structure, and internal rules. For instance, a company's articles of association might state that its purpose is to develop software. And finally, bylaws are detailed rules and regulations governing a corporation's internal affairs. Bylaws might specify how the company's board of directors is elected and how often meetings are held. Understanding these 20 fundamental legal terms is a significant step towards greater legal awareness. This knowledge empowers you to comprehend legal documents more effectively, communicate more confidently with legal professionals, and make informed decisions in situations with legal implications. Remember, this is just the beginning. The world of law is vast, so continue exploring legal concepts and terminology. Your ongoing journey to legal literacy will serve you well throughout your life.